We're going to readdress Anthony Miller.
Your Honor, may we approach?
Yes, this is, hold on, I don't have the case number in front of me. 21MM8833. Oh. All right, so if there's updates to this dependency case plan or anything else that you need me to look at, I need to see that. Because I have the dependency case plan, but you just told me, Counselor, that you have some updates to that, so I need those. Okay, you can, but it doesn't matter. That's what you just unplugged over there. So it was, now it's off. Now it's on. Okay. Well, hold on, I just redid it again, see if that works. All right, then here's what we're gonna do. We're gonna move him again to the end of the docket. Can you have someone in your office do this work so that it can be done while we're in court?
Your Honor, no. Everyone is out. I am here today now.
All right. Unfortunately, Ms. Howell, we're gonna have to put him at the end of the docket again because I still don't have all the information I need. Can you bring her in here? I just wanna make sure she understands what we're doing. So, Ms. Howell, I'm not saying that you have to stay here for this. I'm saying you are welcome to stay as long as you can.
Yes, ma'am.
I have no idea how long it's gonna take.
Yes, ma'am. I also have the updated case plan and every document for the DCF case plan right here.
Do you wanna give her an email address where she can send it to you?
Are you able to email?
Sorry it's taking so long, but we gotta get all the documents.
You're fine, Your Honor. Take your time. Your Honor, if I may speak, Your Honor.
Sir, you can say anything you want. Remember, I told you before, everything you say is being recorded and can be used against you.
Yes, ma'am, no problem.
You understand that?
Yes, ma'am, no problem.
Go ahead.
I just wanted to let you know and make sure that you were aware that last week I just had a a case plan, a court date with the CPS judge, and me and Brianna were present together at my home
That's what your attorney just said.
on the phone, on the line with the judge. And
So
everything was fine. So if there was a violation of my contact order, I'm pretty sure the judge then on the line would have violated me then, ma'am.
they could have,
The office, I'm sorry for cutting you off, ma'am.
sorry, I actually cut you off. I apologize. I thought you were finished. I was going to say they could have. I don't know why they didn't. I understand that what you're saying is that would tend to imply that there was not a violation.
Yes, ma'am.
I understand. Go ahead. I didn't mean to cut you off.
I'm sorry. And today, well, not today, yesterday, while I was there at the house waiting to see what was going on, an officer showed up at like 3 o'clock, came to do a wellness check, walked inside of the home, checked the home, no one was there. They left. They then waited 4 or 5 hours, came back, didn't say anything, forced me to open my door with guns drawn, and put me in handcuffs while I was packing my belongings, ordering my Uber to leave.
I understand. Were you there at 3 o'clock when the officers arrived?
Ma'am?
Were you there at 3 o'clock when so you did speak to the officers?
Yes, ma'am. I was in the house present with the officers. They came there they said they had a call for a domestic violence call. And no one was there but me. I don't understand why that's not in the what is it called?
The probable cause affidavit?
The affidavit, yes, ma'am.
It could be because that was different police officers. So the officers who wrote this affidavit are the ones who arrived at 11:38 p.m.
Yes, ma'am.
So if those were different officers, it was the same officers?
It was one of the same officers.
Okay.
It was a taller black gentleman, he wasn't there. But the Hispanic guy that actually wrote the statement, he was the one that showed up there first.
So he must not have found probable cause for anything the first time that he went.
But when he came back the second time, it was the same thing. I was there by myself, but this time packing my belongings to leave.
I understand.
Yes, ma'am.
All right, thank you. So what I'm gonna do, oh, did she leave?
No, I'm ready.
Oh, I was like, Ms. Howe, you can leave. You can leave anytime. You're free to leave. I'm not requiring you to stay. But in order for me to look at all the documents, we're gonna continue with the docket because I have 30-something other people to see, and then we're gonna address this one at the end. So if you are able to stay, you are welcome to stay here. If you need to leave, you are free to leave. I'm not requiring you to stay.
Yes, ma'am.
All right.
Did she want to give me an email?
Oh, yes, it's AKUSTIN@circuit9.org.
Okay, I'll send them right over to you.
Thank you so much.
All right. I'll see you back in a little while. I'm sorry for all of these delays.
Yes, ma'am.
All right, we have Creole next. We have an interpreter.
Over there.
John Black.
This is Judge Gibson. Who do I have on the line?
Hello, Judge. This is Fania, your Haitian Creole interpreter.
Has the interpreter been sworn?
Not yet, Judge.
Please raise your right hand to be sworn.
Do you swear to interpret from Creole to English, English to Creole, the testimony you will receive today?
Yes, I will.
All right. Mr. Blanc, you're here in 21 CT 3958 because a capias was issued for your arrest.
Give me 1 second, Judge.
What are these?
OK, Monsieur Blanc, ou là dans 2021, c'était parce qu'un KPS, j'étais passé un KPS pour un mandat d'arrêt.
The capias is for failing to appear for a status hearing on a charge of no valid driver's license.
KPS là, c'est peut-être ou pas apparaître dans le tribunal et en rapport avec une licence qui était en suspension.
The bond authorized on that capias is $1,000.
1 second. second, judge. Caution qui est autorisée pour mandat d'arrêt, ça, c'est $1000.
I'll appoint an attorney to represent you.
Ou qu'à chercher un avocat pour représenter vous.
Good luck, sir.
Bonne chance, monsieur.
Thank you.
Thank you.
All right, thank you. I believe that's all we have for the interpreter.
Thank you for using our services. You have a good day. You be safe and happy holidays.
You as well, thank you.
Your Honor, I did provide an order for Mr. Powell to the clerk. I'm not sure when you would like to address that one.
I signed it.
Thank you, Your Honor.
Kian Calhoun Medina.
Good morning. You're here in 21 MM 618, charged with 2 counts of battery. At this time, I'm going to appoint an attorney to represent you. Counsel, did you have an argument to make in this case?
Yes, Your Honor, I'm arguing that the add-on bonds not be revoked. You take no action. As the client is attempting to get into mental health court, there's obvious mental health concerns. We ask you to take that into consideration and not revoke that add-on bond.
All right, thank you. There is probable cause. What effect would revoking the bond have on his ability to get into mental health court?
Your Honor, he is already engaged in treatment and supposedly participating with, where is it, Aspire or Lakeside? With Aspire. He's supposed to be attending weekly therapy sessions as well as reporting with Lisa Vargas, who is the mental health counselor, before he gets into mental health court. We ask that so he can continue, working towards regaining. I think based on this report, it demonstrates that he does need some mental health support.
What says the state?
I'm sorry, I didn't follow. He's in mental health court now?
No, he is actively engaged to sign contract in the future. I was looking at the notes. Lisa had emailed, Ms. Vargas had emailed that he needs to be maintaining these appointments that he has with treatment. You do treatment and get assessed prior to signing contract.
This occurred in the hospital.
When he was about to be Baker acted, Your Honors.
Right.
I apologize. I leave it at the court's discretion. I really do apologize.
All right, sir, in this case, your bond will be $500 on each count. With special conditions, you can have no contact with the victims or any witness in the case. You can't possess a weapon of any kind, firearm or ammunition. I'm going to order that you cannot return to Advent Health Apopka, that hospital, unless it's a medical emergency or you have an appointment. Do you understand?
Yes, ma'am. Question?
Yes, sir. You can ask anything you wish.
What if you have nobody to contact for bond?
I'm sorry, say that again?
If you have nobody to contact to help you get to pay for your bond?
Your attorney will help you with that. I'm concerned, counsel, because his out-on-bond cases are both violent, and this is a violent offense. Tell me again, what effect would it have on his ability to get into mental health treatment if I revoke those bonds?
It probably will have no effect on him getting in, but what it will affect is him accessing treatment. He has, appointments scheduled with Aspire and Lakeside already that are scheduled in order for him to, it might hurt him getting in because he can't show that he's participating, but really it's just prolonging any sort of mental health help that he's getting.
When are these appointments?
I don't know the dates. I just know that they're scheduled per the email in the system.
I have one in January for a refill of my medication. I just started.
There also should be weekly treatment. Weekly, Therapy. I don't know what they are, though.
I'm sorry, this is a violent offense. He's out on bond for violent offenses. At this time, I'm going to revoke that bond. So here's what I'm going to say. Mr. Calhoun Medina, you need to stay in touch with your attorney because I will ask that you please make a note for your colleagues to file a motion in front of the trial judge right away.
I don't understand what you just said. Could you?
I'm asking your attorney to make a note for her colleagues who will be working on this case to file a motion in front of the trial judge, but at this time, I am going to revoke those bonds. Good luck, sir.
So does that mean I'm here stuck in jail?
Right, you cannot bond out at this time. Please tell me your name.
Jack Clark.
21MM8827. You're here charged with resisting an officer without violence and possession of drug paraphernalia. Was there an offer?
Not at this time, Your Honor.
All right, I'm going to appoint an attorney to represent you, Mr. Clark. Did you have an argument on probable cause, counsel?
No, Your Honor, I do believe there's a possible motion in the future, and I ask that you take that in consideration when you're thinking about revoking or setting a bond. Additionally, the case that he's out on for petty theft, he's engaged in pretrial diversion for, is my understanding. I don't understand the new pretrial diversion stuff. When I was there, it used to be it got abated, but now I think you just take a class, from my understanding.
I have to watch a video.
Watch a video.
About 4-hour video.
So that's what he's actively engaged in. So we ask that the add-on bond not be revoked in the new case, take in consideration that there's a possible motion there as to, you know, the stop.
I reviewed the affidavit, sir. I do find there's probable cause for these charges. Your bond is $500 on count 1, $100 on count 2 with special conditions. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. I'm inclined to revoke his bonds because he's out on bond for possession of cocaine and drug paraphernalia and just got arrested for another possession of drug paraphernalia.
And we ask that you don't, as they're victimless crimes, and there's no indication that he's selling or using any sort of large amounts.
But you can't get arrested for new law violations if you're out on bond, sir. Especially this, 2 of the charges are the same. What says the state?
Your Honor, I think you could revoke and double.
All right, based on your attorney's arguments, I'll take no action on this, on those at this time, sir. Good luck.
My name is Dennis Martin.
21MM8830. Mr. Martin, you're here charged with battery. I'm going to appoint an attorney to represent you. Counsel, did you have an argument in this case
Your Honor.
on probable cause? I agree. There is probable cause here. Sir, your bond is $500. With special conditions, you can have no contact with the victim. You can't possess a weapon of any kind, firearm, or ammunition. Give me one moment.
Can I ask you a question, ma'am?
Yes, sir. You can ask anything you wish, but everything you say is being recorded and can be used against you later. You understand?
Yes, ma'am.
Okay, go ahead.
What he did first, see, I'm not a person.
I'm going to give you a moment to talk to your attorney first. I'm going to give you a moment.
Don't talk about facts of the case at all. You'll talk to your attorney about that, okay? Don't talk about any facts of your case.
I'm not the type of person that, see, he's like me.
No, I'm saying don't talk about any facts. Okay. Got it?
All right, Mr. Martin, I think it's smart to listen to your attorney's advice. What I'm going to do is I'm going to order that you must maintain a separate residence from the victim, but I'll allow a one-time return with law enforcement to gather your belongings. Good luck, sir, and stay in touch with your attorney, okay?
Your Honor, what was that bond amount? I'm sorry.
$500.
Thank you. Here you go.
Fernando Rivera Soto.
21 MM 8814. Good morning, sir. You're here charged with petty theft. I'm going to appoint an attorney to represent you. There is probable cause. Give me a moment. Your bond is $500 with special conditions. You can't return to the Walmart located at 3101 West Princeton Street for any reason or have contact with any witness in this case. Do you understand, sir? Yes, ma'am. All right, good luck. Good morning, sir. You're here charged with trespass on property after warning in 21 MM 8820. Was there an offer in this case?
Yes, Your Honor. It was an adjudication, credit time served, and no return to Wawa. Mr. Smith would like to accept that.
Please raise your right hand.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God? Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Did he say yes?
He did, Your Honor. Yes.
All right. Sorry, sir. Sometimes it's hard for me to hear, especially with the masks. We have to leave them on, but it just makes it more difficult. All right. So, Mr. Smith, you had the opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest this morning. Do you understand those rights? Do you have any questions for me about them?
No, ma'am.
Do you understand that if you're on probation anywhere, this plea could violate that probation?
Yes, ma'am.
You understand that if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
Give me one moment. All right, sir, at this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea, sir. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay those. And order that you not return to that Wawa.
Yes, ma'am.
All right, good luck, sir. You have 30 days to appeal in writing.
What color does he get?
I have to sign all of them. Right.
Emmanuel Strickland.
Good morning, sir. You're here in 21 MM 8829, charged with possession of drug paraphernalia. There is probable cause. Was there an offer?
State announces a no information.
All right, sir, at this time, the state has dropped the charges against you. So unless you have anything else holding you, you'll be released today.
Thank you. That's good news. Thank
Yes, sir.
It was
Thank the state.
Good, good, good.
Please tell me your name.
Sean Dwayne Thomas Jr.
Good morning, sir. You're here in 21 MM 296, charged with resisting an officer without violence. Was there an offer in this case?
Your Honor, there was. I do not advise he accepts it at this time, due to the fact he's out on bond. It is out on bond on 1 felony and 1 misdemeanor, and also I believe that can I just have a second, Your Honor?
Yes.
Your Honor, my client would like to accept the offer.
Which is,
Adjudication of guilt and credit time served.
all right, Mr. Thomas, I need to make sure that you understand that even if you enter a plea of guilty or no contest to this charge today, because I show that you're out on bond in 2 cases, one of them is attempted robbery by sudden snatching and battery domestic violence, I may still revoke those bonds and hold you at no bond. Do you understand that?
Even if I do take the plea or not, it's
Right.
the same?
Either way, I may still revoke those bonds. I have not made a decision yet. So I want to make sure that you're not accepting a plea agreement in the resisting without violence case, thinking that guarantees that I will not revoke those bonds.
Yeah, yes, well,
So you understand that I may still do that. All right, I'm going to give you another moment to discuss with your attorney whether you want to accept that plea from the state. I'll accept it if you want to do that, but I may still revoke your bonds.
Okay. All right, Your Honor, my client understands that we are requesting that the bonds not be revoked as they're completely unrelated charges, but he does understand the risk, and that is not why he's resolving this case. He just would prefer to not deal with this in the future.
All right, please raise your right hand, sir.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
All right, Mr. Thomas, you had an opportunity to discuss with an attorney. Actually, I'm going to appoint your office to represent him, counselor. You had an opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yeah.
Do you have any questions for me about them? I'm sorry, I couldn't hear you. You don't have any questions?
I have a question, but
Go ahead, what's your question?
I was just saying, like,
Hold on, get closer to the microphone.
I was saying, though, like, the charge that I came in here on last week, the person, or the victim, whatever, they said that it wasn't, they didn't want to press charges or nothing like that, so,
No, this is a resisting an officer without violence charge.
okay,
Are you talking about your out on bond case?
yes,
Okay, hold on, we'll get to that in just a minute.
yes, ma'am.
But you're not entering a plea to that charge today. This is just the resisting an officer without violence. But still, you understand that you have the right to remain silent, the right to testify on your own behalf, the right to require the state to prove the charges against you beyond all reasonable doubt at a trial by jury when one is required. But you're giving up those rights if you enter a plea of guilty or no contest. You understand that? You also understand if you're on probation anywhere, this plea could violate that probation. I believe you, but I have to ask everyone because I don't know. It's possible you could be. And if you're not a U.S. citizen, you could be deported. You understand? All right, understanding all of those things, sir, and as we've previously discussed, at this time, the court has not made a decision about whether I'll be revoking your out on bond cases. Understanding all of those things, how do you wish to plead to the charge of resisting an officer without violence?
No contest. No contest.
I'll accept your plea, sir. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. I have to order that you pay court costs, sir. I'm going to give him a year from the date of release. You know what, can you just not write that yet? Because I haven't made a determination about whether I'm going to revoke his bonds. So if he's released today, then it'll be today. Just give me a minute. All right. All right, so you have 30 days to appeal in writing. Counsel, why should the court not revoke his bonds?
Your Honor, it looks, well, just from my client stating that the victim didn't want to go forward?
Yes, she didn't want to.
Okay, sorry.
Excuse me, I know I'm supposed to be talking too much now, but.
You can say anything you want to say, it's just being recorded, and the state can use it against you later.
When I came, my baby mama girl I stayed with, she came in here and said that she didn't want to proceed with nothing. Then she said the state attorney already called her a couple of days ago, and they said that she didn't want to do no further.
So, Your Honor, I understand that that is, my client's testimony and the alleged victim isn't present, but we're arguing that also, not only just that, but these charges are just completely unrelated. There isn't
Every time I come to jail, it be the same person's name being the same, the same.
there'll be there's no allegations of a resisting without violence that he's out on bond for, so I understand he's not allowed to commit any new offenses, but it is unrelated, and he is, now that case is closed, and we only have these, the out on bond cases. So we're asking the bond not be revoked so he can appear to court on his own,
What
if he
says
is
the
able to
state?
get out.
I just started working too.
What says the state? Also, he has an active warrant out of Indian River County. Is that accurate?
That's correct.
So he might not be released today anyway. If there's a hold for that, he won't be released anyway.
So, Your Honor, that furthers my argument that if we don't revoke it, he can actually go to River County and deal with whatever that is there. Because if you do revoke these bonds, then he won't be able to handle any cases that are possibly pending.
He will not. Anything from the state?
I was just trying to confirm why he was being arrested. It was on the warrant for the attempted robbery, correct?
I don't have that affidavit in front of me now.
Your Honor, the out on bond
No.
cases,
He was stopped because it was a vehicle stop. It was a
Okay.
traffic stop.
okay. His out on bond case is a trespass, which would be a misdemeanor, and he could resolve that today if he wanted to. With regard to the felony, he was arrested on December 5th, but the state hasn't filed charges yet. At this time, I would have no objection to a revoke and double, as he was just arrested. Yeah, I would have no objection to a revoke and double, Your Honor.
Thank you. Anything else from the defense?
Your Honor, I'm just looking at the original felony to see if we could resolve that case as well.
You cannot.
Oh, okay. No, Your Honor.
I can't. I cannot resolve the felony.
Oh, it's a misdemeanor. The trespass.
Oh, no, I thought you meant the attempted robbery.
No, I understood. It hasn't even been filed on, so no one can.
Right, I'm sorry. I thought that's what you were saying, and I was like, nope, we can't do that today.
I was just seeing if we could possibly resolve that misdemeanor. It looks like if Your Honor would take a plea on that, Mr. Thomas could on my end. And as for the attempted robbery, it hasn't even been filed on at this point. So again, we're asking if you do revoke to revoke and double, but we ask you don't even revoke and just take no action.
Mr. Thomas, I'm going to take no action on those cases. Don't come back and see me. Good luck, sir.
Your Honor, my name is Marquise Leomai Hill.
Sir, you're here in 20 MM 1971BO because a capias was issued for your arrest.
Yes.
Oh, yeah, 1 year. For failing to appear for arraignment on a charge of petty theft of $100 or more. The bond authorized on that capias is $500, and I'll appoint an attorney to represent you.
to take a deal is what you're. Right, Your Honor, my client would like to take the state's offer. It's an adjudication credit time served and no return.
I don't know that I'll accept that. I don't have an affidavit or anything in this case. It's a capias. So what's the reason for the state's offer and who's the victim and where was it?
So
Just a moment, sir. I'm asking the state. It's okay.
Your Honor, he's accused of snatching items off of a countertop in this particular store. He does have history, but his last conviction was 2018, and it's for a misdemeanor of possession of cannabis less than 20 grams. There is also restitution ordered in the amount of $453.57.
Your Honor, my client would rather be released ROR, but I understand that it's a failure to appear, but during the pandemic, he had been calling to determine his court date and was told there was no future court date, and that's how the failure to appear was issued. So
So I can't change a capias, counselor. It was signed by another judge, so I'm not able to change that. There's a bond authorized on the capias. You have to ask that judge to change the capias. What's the store? I don't even have a probable cause affidavit.
The store is SoCar Smoke Shop, located at 3405 Sebring Avenue.
Give me the name one more time. So,
S-O and then C-A, SoCar.
okay.
SoCar.
All right. Thank you. All right, I will accept that plea. However, Mr. Hill, your attorney just said that you would rather be released on your own recognizance. I'm sure you heard me say I can't do that because it's a capias signed by another judge. But I want to make sure that you understand that if you enter a plea today simply to get out of jail, you're going to have a criminal conviction for petty theft on your record. Petty theft is what we call an enhanceable offense. What that means is after a certain number of offenses, the state can file this misdemeanor petty theft as a felony. So entering a plea to a petty theft simply to get out of jail today may or may not be in your best interest. That's up to you.
The thing is, I don't want to lose my job. I have to be to work tonight, actually, and I just don't want to lose my job. I got a little daughter, and I'm just trying to get out so I can go back to work and not lose my job. I don't even want them to know that I had to go to jail. I've been staying out of jail for 3 years, and I just been working, so I'm not trying to mess up my reputation just for like something that just came back on me.
Right, but now you'll have a conviction for petty theft if you enter a plea of guilty or no contest. So it will absolutely affect your reputation moving forward. You'll have to disclose it on job applications, et cetera. So I just want to make sure you understand that.
I just really can't stand this, just staying here any longer. I want to really get back to my daughter. I know for sure I'm not going to get in any trouble. I haven't been in trouble in the last 3 years. This was something old. That's not me anymore. Like, I've been clean slate.
I understand what you're saying, sir. Those all sound like wonderful arguments to make in front of the trial judge so that you don't have a conviction for petty theft. You understand that what you're doing today isn't going to help you move forward with your life. You will now have a conviction for a crime of moral turpitude.
It's like, if I don't want to stay here, then I'm gonna set back.
There's a bond authorized on the capias. It's not a no bond capias.
I don't really got no money right now to bond right now. I don't got no money.
Can we bring him back in a minute? I don't think I'm inclined to accept that.
Your Honor, Walker Reginald, Aurora.
Okay, I don't have him.
Brooks Adonis, he's in the hospital.
2016 MM 8393, it's a capias. I'll appoint your office to represent him.
Your Honor, I can waive his appearance. It did look like there was a bunch of other stuff as well for his name when I pulled up his affidavits. There might have been like an out-of-state warrant.
He does have, it looks like 2, fugitive from justice.
He did want to sign the waiver, which I guess he can't. He's not here.
The bond on this is $2,000. All right. I have next Daryl Lindsay.
Darrell Lindsay.
Good morning, sir. You're here in 21 MO 1478, charged with open container of an alcoholic beverage. Was there an offer?
Yes, Your Honor, it's a withhold credit time served and court costs.
Did you talk to
My
him
client
about
would
that?
like to accept it.
Please raise your right hand, sir.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
All right, sir. There is probable cause. You had the opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, I don't.
All right, you understand that if you're on probation anywhere, this plea could violate that.
Yes, ma'am.
You understand that if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
All right, sir. At this time, how do you wish to plead to the charge of open container of an alcoholic beverage?
Guilty, Your Honor.
I'll accept your plea of guilty. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in custody. Sir, I have to order that you pay court costs, but I'll give you a year to pay those.
Yes, ma'am.
It's around $300.
All right.
All right. Good luck, sir. You have 30 days to appeal in writing.
Your Honor, Marcus Aponte, bonded,
Okay.
and Aaron Barber, who's in the hospital.
21 CT 8124. It's a DUI. I'll appoint the public defender's office to represent him.
Your Honor, I'll waive his appearance.
All right, his bond is $500, cannot possess or consume alcoholic beverages or any controlled substance. He'll be subject to random drug and alcohol screens. He cannot drive without a valid Florida license.
Rafael Gonzalez, bonded.
Rock Wolfram Jensen.
Good morning, sir. You're here in 21 CT 8126, charged with driving while license suspended, and 21 MM 8813, charged with possession of drug paraphernalia. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500 on the paraphernalia, $500 on the driving while license suspended. Sir, you can't drive without a valid Florida license. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. I'm inclined to revoke his bond, counsel. He's out on bond for driving while license suspended.
Your Honor, I'm arguing that you don't revoke it, or if you do, you revoke in double, although I believe that would be adverse to what I'm trying to achieve here and what the client is. He is currently working on getting his driver's license back. He is working with an attorney at my office to pull his costs out of collections and get him on a payment plan in which he's actively engaged and involved. So I'm asking that you don't revoke at all, because you know how this is. It's a money circle.
Yes, it is. And your office is actively working with him?
Yes.
What says the state?
No objection.
Mr. Jansen, I'll take no action on those cases. Good luck and Merry Christmas.
Thank you very much.
That's for you. Don't drive.
I'm not.
Dr. Reginald Jones, bonded.
Your Honor, I actually had a probable cause argument on that one.
But he bonded.
I know. So, I'll waive his appearance if you're appointing me.
Well, he bonded, so
Oh, you can't.
I don't think I can.
Okay, okay.
Sorry.
Saying.
Good morning, sir. You're here in 21 CT 8128, charged with driving while license suspended or revoked. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can't drive without a valid Florida license. Good luck, sir.
Here you go.
All right, just for everyone, I have that hard stop because I have a meeting. I don't think we're going to get back to Mr. Miller's case.
I did find some of the updated orders. We only have 4 minutes. I'm not sure if that's enough time, and then
I can stay a few, oh, no. Hold on one second. Sorry, I'm texting Judge Bigney about your other client because
you.
she's the one who signed the capias, so just so everyone knows I'm not distracted in court. I'm trying to. Okay. I just hate for her to keep sitting here,
I know.
but I might need to review that over lunch during my meeting.
There's only 3 more documents since that case plan.
Okay?
You want to try?
Yes. Wait, who is this? Mr. Bates. Let's do Mr. Bates, then we'll bring Mr. Miller back in. Let's see if we can accomplish that before we have to break. And I'll stretch it as long as I can. Are you Mr. Daniel Bates?
Yes, ma'am.
Good morning, sir. You're here in 21 CF 15768, charged with possession of MDMA. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. Counsel,
I have an argument on his out on bond. He is attempting to get into Veterans Court, as what I understand from now. He obviously has a drug issue. I'm not sure about what happened in his veterans history, but maybe that's a contributing factor. And we argue this is a nonviolent crime. There's no indication of sale or delivery or anybody being harmed besides Mr. Bates himself.
Mr. Bates, in what service did you serve our country?
The Army.
In the Army? How long were you in the Army?
I served for like 2.5 years, but I had got an early discharge.
Where were you?
Station.
Yeah, where were you stationed?
My duty station was in upstate New York. I was in Fort Bragg.
Well, thank you for your service. Sorry, the reason I said counselor was I started reading and I'm seeing, I'm going to change that bond to $500. I'll take no action on the out on bond. Mr. Bates, you can't possess or consume any controlled substance or have contact with any known drug dealers. Do you understand? All right, good luck, sir. Give me one moment. right, sorry about that. Let's go back to Mr. Miller's case. I have some paperwork in front of me. Tell me what you have, counselor.
There was a modification of their contact. There is an order to modify or amend the parent's visitation. This was filed on 12/1. The motion is granted. The mother and father may have supervised visitation with the above named child at the same time. It shall be supervised only by an adult approved by the department, which I mean, this is so confusing. I believe they mean Brianna Howell. There's no indication of who that is. And there shall be no hostile or violent contact during that supervision. Additionally, there's an order from 11/15 following the contact that was approved with the criminal case, so different than the original case plan from when I had previously looked at it. The 11/15 order indicates that it's been modified to no hostile contact by the criminal court, and parents must reside in separate residence, may have contact but no hostile contact, and apply with our dependency case. He may not live in the home with the mother per criminal court visit. This one does say visit separately, but the modification order from 12/1 says that they don't have to visit separately. In fact, that they are allowed to have supervised visitation together. Also, the most recent court document indicates that the father has been complying with the case plan, which I think is the most important part as to determining whether or not the bond should be revoked, that he is making efforts to comply. I think that this is all so confusing, and that should also be given to Mr. Miller as showing that if we can barely understand this, how could he? And there's nothing indicating that there was anything violent happening at all. Nobody indicates that whatsoever. So we're just asking that the bond not be revoked. Again, the state has no objection to that as well.
So here's my only concern. The only thing I'm seeing is the father and mother may have supervised visitation with the child at the same time. Supervised visitation shall be supervised only by an adult approved by the department. No hostile or violent contact during the supervised visitation. I don't see anything in any of the documents that I have found that says that he's allowed to be at her residence. I thought someone said, hold on, I thought somebody said that there was something that said they were allowed to, that that's where he's supposed to be watching a child, but I don't see anything that says that. And so I still think there's probable cause that he violated the condition of not living there. It appears he was living there. I understand they're both saying he wasn't, but it definitely appears that way. I'm not, does anybody have any paperwork from any judge that says he's allowed to be at her residence
There's just no.
all hours of the day and night without a child being present? I don't see anything. Again, you can say anything you want, Mr. Miller, but remember, this is being recorded.
That one. Your Honor, my issue is there's nothing indicating he has to have separate residence that he can't have contact with the child or watch the child in any of these reports. It does say separate residence for sure, but I
Right.
still think, let's say there's probable cause for that. I think that's assuming that someone doesn't have a separate residence because they're somewhere at 11:30. There's nothing saying that he can't watch the child there, especially with this modified no contact order saying that he is allowed contact with her and contact with the child, and they're allowed together at that same time. So if for some reason you do find probable cause, my argument is that this is so minor that the bond shouldn't be revoked. And this is pretty confusing, and there's no indication that anyone's being harmed. In fact, the only thing he's doing is trying to help.
May
So,
I say something?
but here's the problem. Just a moment. I'll get back to you, Ms. Howell.
Yes, ma'am.
Here's the problem. He tells law enforcement he was at the house at 7. He just told me that law enforcement came at 3, and he was there and no one else was there. He told law enforcement he was there at 7 to watch the child, but both of them have said the child wasn't there. Law enforcement went twice during that day. There were no children present. So there's no indication to me that your client was at that house to watch a child. The indication is that your client was at that house for some other reason. I don't know what the reason is. It's possible that he was living there.
It's also
it's-
possible he wasn't. There's no indication he was.
It is possible, but it's not possible that he was there to watch a child who was not present at any of the times law enforcement went to that house. And he just told me that earlier today. This is a problem. I think that what's happened is, I'm basing this on something Ms. Howell said earlier. There are multiple children involved, and so this order has to do with some children and doesn't have to do with another child. So I think your client and the victim came up with a solution themselves that may be okay, but it also may violate court orders, and that's not something you can do when you're involved in a case like this. There's both a criminal case and a dependency court case. So you can't just come up with your own solutions that possibly violate court orders. Now, Ms. Howell, you wanted to tell me something else?
Yes, I wanted to state, because you pointed out the fact that the documents didn't say anything about him being at the residence to care for the child. But I just wanted to point out that the document also doesn't state that it has to be in a specific place.
No, but it has to be with a DCF caseworker.
Not with this child.
So that's what I'm saying. So I think that what's happened is your client and the victim have developed a workaround that works for them because there are multiple children involved.
Your Honor.
That's not something they can do at this stage, however, because of the cases that are pending. You have to make decisions based on court orders. Yes, Mr. Miller.
Yes, ma'am. You saying that me and my wife made a decision to watch our children together, but like I said when I first came in, Your Honor, we had a court date with CPS, who has the right and made the contact order. We had a court hearing with them on live, and they see me in my residence for the court order with me and Brianna sitting next to each other with my same exact child, Your Honor.
I just.
No, what I'm saying is that the court order does say you can supervise the child together, but there has to be a DCF person present.
No, that's with my son, Your Honor.
Right.
That's for AJ, Anthony Miller. We're
Right,
speaking about serenity.
I believe you. I believe you. That's what I'm saying. Because there are multiple children involved. I think what they did was come up with a plan that works for them. But you can't do that when you have a criminal case pending that has court orders and you have a dependency case pending that has court orders.
Your Honor, I'm arguing that it doesn't violate the court orders. The fact that he's there trying to watch the other child doesn't say he's not allowed to be there. They just have to have separate residences. Now, if I'm not 100% sure what the legal definition of residence, but I believe you get your mail somewhere. That's usually what comes to mind when you're talking about residency. And I think that's really the crux of what we're saying. Which part of this court order is he violating? And I believe we're trying to determine whether or not he's violating the separate residency part. Is that the part that you're concerned by?
Yes, because you're correct. You get your mail somewhere. But I can get my mail at one location and sleep in another. The point of the court order, because this is a violent domestic case, the point of the court order is not concerned with where your client gets his mail. It's concerned with protecting the victim of the violent case and the children who are part of the violent case. It appears this child that your client is now babysitting during the day is the one with which she was pregnant when he's accused of beating her. So the point of the court order is to protect her and the child. It doesn't matter where he gets his mail. Hold on. So staying at her residence for 16 hours a day under the guise of I'm babysitting the child, even though the child isn't there, may comply with something, but I think it's violating the court order because the purpose of it is they must maintain a separate residence for her protection and the baby's protection.
Your Honor, I also argue we always tell the defendants in court, I don't care where you go, but you have to have a separate residence. If she's there,
Right.
you can't be there. This police report indicates she was not there.
Right,
This could have been his residence at that time. That wouldn't violate the court orders.
but it's her
She's not there.
residence
But why do we say that? She wasn't there.
because it says that in the affidavit.
I mean, I just feel like every time we say it doesn't matter whose resident it is, as long as she's not there, you can go back. If she's there, you can't go back. So then it's going to another different level of this, that he's still not violating that court order. That maybe she wasn't even, maybe they, it wasn't her residence. If we're only talking about this, police report, if we're not getting into all the rest of it.
So her address in the dependency case plan as well as his address in the dependency case plan, are this address. So it is her residence because that's what's in the dependency case plan as well.
So then they're following the dependency case plan, which indicates that's his address.
I think they're not, because it shouldn't be his address. What I'm saying is, in the dependency case plan, it appears evidence that your client's violating the court order because he gave that as his address. Now, that's not in front of this court, so that's for someone else to decide. But I've already made the determination he violated the court order.
Okay,
There's no reason to argue about that now. The only reason I wanted to see all of this is because I'm trying to determine if I should revoke his bonds. Because while out on bond for committing a violent offense, he was arrested for, and I have found probable cause, that he violated a court order. And the court order is put in place to protect the victim and the child. So at this point, the only determination left for this court today is whether to revoke those bonds and/or what conditions to place on him. So give me one moment. Ms. Howell, how old are you?
I'm 20 years old.
20?
Yes, ma'am.
How old is he?
He's 24.
You're 24, Mr. Miller?
Yes, ma'am. Your Honor, if I may speak, Your Honor?
Yes, sir, you can say anything you wish.
Your Honor, I'm sitting here and I'm listening to you, Your Honor, and I respect your opinion 100% because you are right. The contact order was made to protect my wife and my child, Your Honor, but it was not made to protect my daughter, who is standing in that booth right now, Your Honor, and who I arrived at her apartment at every morning, as agreed, in front of the CPP and the CPS court officials who created this no contact order between my children. It was agreed in front of them, Your Honor, that I can be at my residence and watch my daughter, Your Honor. When I was at the residence yesterday, like I explained to you in the beginning of our court case, Your Honor, I showed up at the normal time and no one was there, Your Honor. I sat there and I waited. Me and Brianna, we talked. I tried to figure out what was going on. She said that she wasn't going to be there that day. So, therefore, I tried to find money so I can go get me a hotel room, like I usually do. I leave that place 9, 10 o'clock every night, just when the police arrive. That night, I was there at 10:30, maybe almost to 11, because I was there all day long trying to figure out what was going on, Your Honor.
All right, here's what I'm gonna do, Mr. Miller. Based on the testimony here today, I'm not gonna revoke those bonds. I've already found probable cause for the violation. Mr. Miller, where do you work?
I work for Claywell Pools, ma'am.
Pools?
Yes, ma'am. I'm a pool.
What hours do you work?
I work from, it kind of varies because we have different locations. So during this holiday season, I haven't really been working as much because of the holiday seasons, but I usually work from 9 o'clock in the morning up until maybe 4 or 5 in the afternoon,
How many days a week?
Monday through Friday.
Ms. Howell, where do you work?
I work at Concentrics.
I'm sorry, say that again?
Concentrics?
Concentrics, I'm sorry. With the mask, sometimes I can't hear.
But it's currently remote.
Okay. I've never done this before, Mr. Miller. I'm gonna set your bond at $500 on that violation. I'm going to order that you must comply with all of your other court orders. Now, I told you what I think is happening. I think it's confusing because there are multiple children, and so I think you guys have developed a plan that works for you. But you need to talk to your attorney as soon as you can because, well, hold on. Because I think there is evidence, there's probable cause that you violated that, but I also think that I'm choosing to believe you and Ms. Howell today about what was going on here. You may not get that chance again. And so if this stays this confusing and you get arrested again, first of all, I don't know that you'll appear before me. It could be a different judge. So we've spent a lot of time trying to sort through a lot of documents right now. I don't know that that will happen again. So what I'm telling you is, if I were you, I would talk to my attorney right away, explain what just happened, and figure out what it is that you guys can do to make this really crystal clear. Because I don't know if the state's gonna pursue this charge, and I don't know what the judge is going to do with this misdemeanor, but I'm going to give you the benefit of the doubt today.
Thank you, Your Honor.
I don't think I've ever set a bond at $500 on a violation case, and this is a domestic violence case. But I find it an unusual case, and Ms. Howell, I'm believing you that you are not afraid of him, but I just want to say, if anything happens that does scare you, you need to immediately call 911.
Yes,
Understand?
Yes, ma'am.
All right, good luck to both of you.
Thank you, Your Honor.
Do you want any of them? It's all the stuff we, thank you, okay. Okay. No, I'm just saying comply with everything else. There's enough conditions there. Well, I need her to come back. All right, so I spoke with Judge Bigney on Marquise Hill. Can we bring him back out? And I
Your Honor, I did
have to
look at his
recess, I'm late
history.
now. I'm sorry?
I looked at his history. It's like very minimal.
All right, so Mr. Hill, because as a function of law, I cannot, welcome back, this is 20 MM 1971BO. As a function of law, I cannot change a capias. However, Judge Bigney is the one who issued the capias, and she is willing to change the capias. Your bond can either be $100 or I can release you on pretrial release.
Your Honor, he's requesting pretrial release. He does have a phone. He'll be able to maintain contact.
All right, then at this time, I'll release you on pretrial release with special conditions. You can have no contact with any witness in the case. And do you have the location, State? So we can tell him where not to return?
The SoCal Smoke Shop, 3405 Sebring Avenue.
All right, so don't go back there while you're on pretrial release. You understand? All right, good luck, sir. And court will be in recess.
Until when?
So our meeting, I think, is until 1:15.
Okay,
So I can come back right at 1:15.
okay.
Hello, Cisco Unity Connection Messaging System.
If we can't get someone, we might have to recall her. Why is this not working?
Hello, Cisco Unity Connection.
It's like a Monday. All right, I'm gonna try one more time. If I don't get an interpreter, we're gonna recall this case after. Recall some others.
English.
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Code Interpreter.
Has the interpreter been sworn?
Yes, Your Honor.
All right, could you please connect with the headset?
Sí.
The defendant can hear me, Your Honor.
Good morning, please tell me your name.
Lianex Nieves Caban.
Lianex Nieves Cavan.
Ma'am, you have a warrant out of Seminole County in 20 CF 1659 for charges of possession of cocaine and DUI. At this time, there's no bond authorized on that warrant. We'll notify Seminole County that you're here so they can transport you. And I'll appoint an attorney to represent you in the meantime. I'll take no action on the out on bond case. All right, good luck, ma'am.
Your Honor, do you have the case number for the out on bond?
21 MM 8141. I believe that's all we have for the interpreter this morning.
Not a problem. Thank you, Your Honor.
Thank you. Twenty-one MO 1473. I'm going to appoint your office to represent him.
This has been reset a few times. From what I'm understanding, it's a credit time served offer. And there's no mental health concerns, but since this is the third reset, if you would like to just go through with the initial appearance and have it set for a future date.
All right, I'll do that. There is probable cause. His bond is $250, cannot possess or consume any alcoholic beverages, and not return to the scene. Behavior. I'm sorry, what? Well, I don't know. They're supposed to be here at 9. Good morning. Please tell me your name.
Lincoln Granston.
You're here in 21 CF 15497. A warrant was issued for your arrest, charging you with robbery and battery domestic violence. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Hold on. I gotta plug that in. I'll stay your bond at $7,500 on count 1, $500 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. Were you two living together? So you can't return to her residence for any reason or be within 500 feet of her residence or place of employment. Do you understand that? Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. When they come up, can you just ask them to tell me their name?
Angel Lama.
21 CF 6727. You're here charged with tampering with a witness to hinder communication to law enforcement and battery domestic violence. A probable cause capias was issued for your arrest, and then the state filed an information charging you with those offenses. Your bond on count 1 will be $1,000. Your bond on count 2 is $500. You can have no contact with the victim. You can't possess a weapon of any kind, firearm or ammunition. Were you and the victim living together?
At the time we were, but I haven't seen her like months.
So you don't live with her now? All right, so there's no reason for you to return to her residence?
I don't even know where she lives at.
Okay, so I'll say that you can't return to the victim's residence for any reason or be within 1,000 feet of her residence or place of employment.
Okay.
Good luck, sir.
Thank you, ma'am. Okay, thank you.
James Massengale.
Sir, you're here in 21 CF 14137. A warrant was issued for your arrest, charging you with aggravated assault with a firearm and battery domestic violence. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. And counsel, I'm not asking if you want to be heard on most of these things, but if you do, please tell me. And if I anticipate that I think you'll want to be heard, I'll definitely ask, but I just want to make sure you understand you can stop me anytime if you specifically want to be heard on something. Okay, thank you. Give me one moment. All right, at this time, sir, your bond on count 1 is $5,000, count 2 is $500. You can't have any contact with the victim or any witness in this case. Do you understand what no contact means? Yes. You can't possess a weapon of any kind, firearm or ammunition. I'll give you 24 hours after your release to surrender this firearm to law enforcement. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. Are there any other conditions the state would request?
No, Your Honor.
Your Honor, my client does not have a firearm, so even though that it is saying that there may have been a firearm involved, there's nothing he can turn in.
All right, I'll strike that condition. Yes, sir, you can say anything you wish. Everything you say is being recorded and can be used against you later. Do you understand that?
I flew in from California, so once I make bond, I go back to California and get my job, and
Yes.
then we'll just.
You just have to come back for your court dates. If you fail to appear for a court date, a judge can issue a warrant for your arrest. It's usually at no bond.
So I have a bond for 5,000, one for 100.
500.
So it's 600, 500.
It's $5,500. But you need to stay in touch with your attorney because you want to make sure you don't miss any future court dates.
Thank you.
Hold on. Yes, the warrant also says you have a condition of you're not allowed to return to the scene. I will impose that condition.
Oh, you can't go back to wherever this happened. I'm not sure where it happened.
Can the state give us the address?
One moment.
I don't have that up right now on my screen. I can get it. It'll just take me a moment.
And Your Honor, my client's just asking because the alleged victim is not his son, that he be able to speak to his son. He just wants to clarify on the record that that would be allowed.
Was his son a witness in this case? Yes. He cannot have contact with his son.
Go back to court.
Right.
So your attorney can file a motion in front of the trial judge at any time, and that judge can change my order. But for right now, you can't have contact with your son because he's listed as a witness.
Right.
So the address is 2879 Conway Road, number 152. You can't go back there.
No, I can't get on plane going to California.
All right, do you have any belongings there?
None whatsoever.
Okay, great. Good luck, sir.
All right, thank you.
Good morning, Calandra Awarden.
Good morning. 21 CF 15797. You're here charged with abuse of an elderly or disabled adult and battery domestic violence. At this time, I'm going to appoint an attorney to represent you. I reviewed the probable cause affidavit. I do find probable cause exists. Give me one moment. Your bond on count 1 is $5,000, count 2 is $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm or ammunition. Were you living at this residence?
Off and on, I'm homeless. So I would go stay sometimes. That's what the issue I started about. They locked me out and I wanted my bag. They opened the door, they attacked me.
All right, ma'am. Is your bag still at that residence?
clothes and my bag is still there.
All right, I'm going to order that you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim or any witness. Do you understand? I'm not done. You must comply with any plan set in place by DCF. You cannot possess or consume any alcoholic beverages or controlled substances without a valid prescription, and you'll be subject to random alcohol screens while you're out on release. Good luck, ma'am.
Morning, Your Honor. I'm Devontae Strickland.
Welcome to an Econo meeting. You are entering the meeting now.
Thank you, sir. Give me one moment. I believe you're represented. Good morning, counselor. This is Judge Gibson. Can you hear me?
Good morning, Judge. I can hear you.
All right. Could you please put your appearance on record
Yes, Judge Rachel Shaw.
on behalf of?
I'm on behalf of, I have Yanae Johnson today and also Devontae Strickland.
All right, I have Mr. Strickland here in front of me. Sir, this is 21 CF 15798. You're here charged with aggravated child abuse and battery, domestic violence by strangulation. Ms. Shaw, did you wish to be heard on any of those charges?
Yes, Judge. We are asking for a reasonable bond on this case. He does have a pending open case right now. It's 2021 MM 4368. It's a resisting officer without violence. He was offered the state diversion program where he does the class and the state will dismiss it. He has completed the class about a week and a half ago. I spoke to the prosecutor on the case this morning. He does intend to dismiss it this morning. So we're asking that his bond not be revoked on that case and instead he get a reasonable bond on this case.
I reviewed the affidavit, Mr. Strickland. There is probable cause. Let me ask the state, have you filed an announcement of no information in 21 MM 4368?
One moment.
Does he have a detainer for his probation?
He doesn't, Your Honor.
I can't hear you.
He doesn't. He doesn't.
So he's on probation, but
He's not a violent felony offender. He doesn't have a detainer.
but he's on probation. So shouldn't there be a violation of probation pending?
If the probation officer files one.
All right.
Your Honor, I'm double checking, but it does not appear that the no info has been filed.
All right, thank you. Ms. Shaw, I show that your client is on probation currently for false imprisonment, battery by strangulation, domestic violence, and simple battery. At this time, I'm going to ask the state, can you please tell me who the victim is in that case?
Any chance, Your Honor, do you have the case number? Just makes it easier to find.
I do not.
Your Honor, would you appoint us on the new cases, the new case?
No, he has an attorney.
Only on the out on bond case, from my understanding.
Ms. Shaw, are you not representing him in the aggravated child abuse?
Judge, not yet. We just found out about this case this morning. We're still in the process of being retained. We're just appearing for this purpose.
Is someone retaining you? Because what I'm hearing from Mr. Strickland is that he did not, I'm not sure if someone outside.
Oh, so we're in the process of it. We spoke to his mother and we spoke to somebody. We haven't officially been retained yet.
Okay.
If you want to appoint the PD for right now.
No, that's perfectly fine, as long as something's in the works.
Your Honor, in 2019 CF.
I'm really having a hard time hearing you. Can you point the microphone at you?
2019 CF 13784, the victim is listed as his girlfriend, ex-girlfriend, Lanisha Robinson.
Thank you. All right, Mr. Strickland, I don't know if your probation officer is going to file an affidavit violating your probation. I don't have it at this time, but I just want you to be aware that that often happens if you're arrested while on probation. So you want to talk to your attorney about that.
Yes, Your Honor.
At this time, Ms. Shaw, because you haven't filed a notice of appearance in this case, I'm going to ask Mr. Strickland, if you intend to hire Ms. Shaw, I cannot appoint the public defender for you at this time.
Yes, they already taken care of my other cases.
Okay, so you don't want me to appoint someone
No.
at this hearing? Okay, then I won't do that. I read the affidavit. I find it extremely concerning. I've also reviewed your client's criminal history. And the fact that he's on active felony probation for violent offenses is very concerning to this court. I show that he has 4 prior failures to appear. Of special concern to the court is that he's out on he's out on probation for domestic battery by strangulation, and he was arrested for domestic battery by strangulation. Also incredibly concerning to this court is, in this case, the victim is a child. Mr. Strickland, your bond on count 1 will be $25,000. Your bond on count 2 will be $5,000. With special conditions, you can have no contact with the victim, any witness, or the co-defendant in this case. Do you understand what no contact means?
Yes, Your Honor.
You can't possess a weapon of any kind, firearm or ammunition. You can't have any contact with any minor child under the age of 18. You can't possess or consume any controlled substance without a valid prescription. You'll be subject to random drug screens while you're out on bond. You must maintain a separate residence from both the co-defendant and the victim in this case. I will allow you a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim or the co-defendant. Do you understand?
Yes.
You must comply with any plans set in place by DCF. Are there any other conditions the state would request?
No, Your Honor.
What says the state as to his out on bond case?
Your Honor, he has filed the completion of the pretrial program, whatever program that was, but he has completed it. So at this time, I have no objection to you taking no action.
When did he do that?
It was filed December 3rd.
I'm inclined to revoke his bond and hold him at no bond, Ms. Shaw.
Judge, I mean, if the state hasn't already no infoed it or no process it, they are going to do it by the end of the day, most likely. So I would ask that you don't do that.
But the reason for revoking the bond is if you're out on bond for committing a criminal offense, you can't get arrested for committing a new criminal offense. It really has nothing to do with whether the state does or does not drop the charges. There was probable cause to believe he committed the offense. He bonded out. He committed a new law violation while being released on bond. However, the state doesn't object. So at this time, I'll take no action on your out on bond case. Thank you, counselor. Have a nice day. Oh, you have another case?
I do. Do you want me to hang out?
Can we bring in Ms. Johnson now? Well, I'll just ask them to bring her in so you don't have to stay longer.
Thank you, Judge.
Yes, ma'am. She was close anyway.
Yanea Johnson.
Ms. Johnson, you're here in 21 MM 8256, charged with battery domestic violence. A warrant was issued for your arrest by another judge, so they've already found probable cause in this case. I have your attorney on the line. Ms. Shaw, if you want to put an appearance on the record for this case as well.
Good morning, Rachel Shaw for Yanea Johnson.
Counselor, did you wish to be heard on bond?
Yes, Judge. We are asking for a reasonable bond on this with any conditions the court may want to put in place in terms of contact. No contact with the victim is fine, but she does not have any open case as far as we're aware. She does have employment, so we are asking for a bond.
Is Eglin in Tampa?
Air Force Base?
Yes.
I think that's in,
Tampa?
no,
No.
that's McDill. It's up in,
Oh, it's in the Panhandle.
yeah, by like Panama City.
I think you're right.
Mhm.
McDill, that's right, okay. Does the state object to pretrial release?
No objection.
Ms. Johnson, at this time, I'm going to place you on pretrial release with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm or ammunition. Were you two living together?
No, ma'am.
I'll order you can't return to her residence for any reason.
Yes, ma'am.
Any other conditions the state would request?
No, Your Honor.
All right. Good luck, and stay in touch with your attorney. You don't want to miss any of your future court dates, okay?
Yes, ma'am.
All right. Sorry, now Ms. Shaw, if you want to be excused, you can.
Thank you, Judge. Have a nice day.
You as well.
Bye-bye.
Avanisha Bell.
21 MM 8823. Ma'am, you're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you in this case.
Your Honor, Eric Hudson on behalf of Ms. Bell, I do argue that there is no probable cause. Upon reading the affidavit, there's actually no indication that there was a touching against the alleged victim's consent. The phone call indicates that I'm sorry, you know, we read so many of these, I did print it out. The witness states that they saw people physically fighting and arguing outside their apartment, but no indication of who did what. And the only thing that we have here is from the alleged victim himself saying that he had scratched himself.
What says the state?
Your Honor, there's an independent witness that indicates that a couple, a black male and female, were fighting. Law enforcement gets to the scene and sees that the black male is injured, despite what he says. The independent witness would indicate that the injuries were as a result of the fight as opposed to him scratching himself, Your Honor.
That's why I initially found probable cause, counselor.
And Your Honor, my issue with this upon reading it was that the only place that it indicates that these people were the ones that the witness indicated was the sentence that says a witness that lives here stated she observed the above listed. But when the phone call came in, it almost seemed like it was just two people, no indication of who they were fighting. So putting it together that these people were fighting and it was this person who was scratched, to me feels like a leap. And that's why I'm arguing that there was no probable cause.
It says a witness that lives here stated she observed the above listed subjects, which are Adams and Bell, physically fighting and arguing outside their apartment. apartment.
Your Honor, to an extent, he does acknowledge that they were at least in an argument, because he says he scratched himself out of anger during the argument.
And Your Honor, my issue is that it is taking three things that if there was more linking it together could be probable cause, but to hear, from reading this, it seems like it's creating probable cause by assuming things.
Where's the assumption?
So the call came in, says, first of all, it was a confidential call, which is perfectly fine, but that a black male subject and black female were fighting outside above listed apartment. So it's just outside, could be any black male, could be any black female.
Right.
There's nothing linking that fight to my client. There is a scratch on the alleged victim, but he's saying he did that himself. So I'm arguing that there's no probable cause that she caused that scratch, that it was her and him in that fight, that there was a battery that happened whatsoever.
All right, so pretend the first part of the probable cause affidavit doesn't exist, the confidential call. Remove that. Law enforcement arrives and they see Adams and Bell,
Outside.
who say, right, outside the apartment, but we're
Their
pretending that the
apartment.
call didn't exist.
It's their apartment, not set up a apartment, it's theirs.
Right. I see. So law enforcement arrives, talks to them. They say they were in a verbal altercation, however, he's bleeding. Later in the affidavit, it says that a witness stated she observed the two listed subjects, Bell and Adams, physically fighting and arguing outside their apartment. How is that? Where's the assumption there? What's missing from probable cause?
The only part that links it is the witness, but I'm not sure if that's the same witness that made the call and the police are just saying.
No, we're pretending the confidential call doesn't exist. Remove that.
Right, I think that's what makes it a little bit more confusing for me as to probable cause, and also his statement saying that he scratched himself. There's no indication it was an unwanted touching.
The indication is from the independent witness who says the subjects were physically fighting.
Right, but a battery have to be something that you're not consenting to?
Yes.
So he's saying that he scratched himself. There's no indication that this wasn't something that he agreed to.
Except the independent witness saying they were fighting.
Which is objective, and his words is subjective. Your Honor, we don't believe there's enough for probable cause. If you do find probable cause, we're asking for a $100 bond.
Well,
Your Honor, if you're inclined to set it at another 24 hours, then we'll agree to probable cause. Because I don't want my client sitting here with no bond.
oh, I'm not inclined to do that.
Oh, okay. That used to happen sometimes when I was here.
It does if the state requests it and there's a reason for that. I think in this case, there's no reason for that. I think that your argument has merit. There is probable cause for some kind of disorderly conduct or a fray. But the charge is battery. Just because he's the one with the injury. Perhaps that is not probable cause for battery. He has an injury. He states, I inflicted it on myself. The independent eyewitness says they were physically fighting. If the physical fight is mutual combat, which there's no indication in the affidavit that it's not. It says they're physically fighting. Where's the intentional touching against his will?
It's listed as a fight, Your Honor.
This is an interesting question. I think I need to think about it. Can we bring her back? All right, I'm going to think about this one. Thank you, Counselor.
Angel Lodra.
Good morning. You're here in 21 MM 8828, charged with battery domestic violence. I'm going to appoint an attorney to represent you in this case. There is probable cause. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means? You have to answer out loud.
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens.
Your Honor, I'm requesting a $100 bond. My client has no criminal history. He is employed full-time. There's no indication that he wouldn't appear to any future court dates, and there's no indication that there'd be any reason to believe a $500 bond would ensure he'd be present to court rather than a $100 bond.
I'm not inclined to do that. Let me ask the state your position.
Ms. Davis, is there a reason he doesn't qualify? Sorry. I don't mind the $100 bond, Your Honor, as he would qualify for PTR.
I'm not inclined to do that. It's a fairly violent misdemeanor battery case. However, if your client wants pretrial release, I will often place them on pretrial release and reduce the monetary bond in conjunction with pretrial release.
Your Honor, that's what I'm requesting.
Oh, I'm sorry.
Oh, no.
Okay.
I talked to him, and he would prefer a lower bond with pretrial release.
Okay, all right. I'll do that then. Sir, I'm going to place you on pretrial release, and I'll reduce the monetary bond to $100 with all of the same conditions. You must maintain a separate residence. I'll allow a one-time return with law enforcement. And you can't possess or consume any alcoholic beverages. You'll be subject to random alcohol screens, still no contact. You can't possess any weapons, firearms, or ammunition. Good luck, sir.
Good morning, Your Honor. Anthony Miller.
Good morning, sir. You're here in 21 MM 8833, charged with violating a condition of pretrial release on a domestic violence case. At this time, I'll appoint an attorney to represent you. Counselor, did you wish to be heard?
Yes, Your Honor. I did pull up the order. The order states that the defendant may have contact with the victim solely to comply with DCF plan. They maintain, I mean, there's a bunch of other stuff, but that's the part that I am focusing on. My client was at the residence. What they do is, what I'm told is that the DCF plan has Mr. Miller watch the child at that house when the alleged victim in the previous case is at work. So what happened that day is he went to go watch his child. His child and mother were not present. Everything was packed up, and he was waiting for the child to appear. Literally was waiting there all day, wasn't living there. They have completely separate residence, and kept calling to try to find out where the child was. Turns out, from what we understand, is that she had taken the child, which is not part of the DCF plan, and he wasn't there violating any sort of court order. He was just there complying with the plan. So we're arguing that there isn't probable cause for this violation.
What says the state?
No objection, Your Honor. I did notice that the court order had been modified to comply with the DCF plan, and that it had also been changed to no hostile contact. As no one was there was no hostile contact.
That further helps my argument.
All right, so it says at the beginning of the probable cause affidavit that she called
I know.
law enforcement and said he was staying at her residence. Does the amended court order allow him to stay at her residence?
I'll double check that, but it just says no hostile contact.
Your Honor, it does say they must maintain separate residence, but the phone number supposedly who called is actually the alleged victim's mother. And the mother had taken the child in trying, I don't know what the situation is, but he was not living there. Finding him there when he could be complying with the court order, I argue, is not probable cause. That's just somebody saying he's staying there. The person who's even living there doesn't indicate that he's staying there. He never indicated he's staying there. In fact, when the police do talk to him, he says everything that makes sense. He never says he was staying there. He was trying to watch his daughter. And why was the daughter not there? Well, all of her stuff was gone and someone else wasn't complying with the court order. So just seeing him there with somebody saying he's living there, that is not enough to violate this court order.
Counselor, you're arguing facts that are not in evidence before this court. The only evidence before this court is this probable cause affidavit. I have no other evidence to review. So if you want to proffer testimony or present evidence, you can do that, but your argument is not evidence.
Your Honor, at this time, I would not like to proffer any testimony, but I only have the court order in front of me right now. I don't have the police report, but the police report does indicate what I'm saying, that what he had said to the police upon originally arresting him, the reason why he was there.
I see that his statement to law enforcement is, I'm here to watch a child.
And Your Honor, I'm just filling in the gaps because I still just think the probable cause affidavit isn't enough for there to be probable cause. I get that it doesn't make sense that he's there, but for me, that fills in the gaps as to why he was there.
Okay, but I can't fill in gaps, counselor. I can look at evidence. That's all I can look at.
But
Sir, while you're in the courtroom, I need you to look at me or this wall. Do you understand?
Oh, yes, ma'am.
Okay. Listen, you didn't do anything wrong, but I don't want you looking at the witness. Now we have a witness here, so that's my normal court order. Just look at me or look at that wall. Don't look at the witness. All right, thank you. Ma'am, do you wish to testify?
Not against him, no.
If you want to say anything, I need you to raise your right hand to be sworn. Go ahead.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record and spell your last name.
Brianna Howell, Howell.
All right, does the state have questions for this witness?
Yes, Your Honor. Ms. Howell, are you the subject of the no contact order that's in place between you and defendant?
Yes, ma'am.
And how do you know defendant?
We've been in a relationship for over 2 years. We have 2 kids together.
Were the terms of that no contact order modified?
Yes, ma'am.
Can you tell me what the modifications are?
The modification was to remain in separate residence, no hostile contact, and in regards to the DCF case that is open for our son.
On December 14th, did you have contact with the defendant?
Yes, ma'am, through text for our daughter. Because he comes to the home to watch our daughter while I work from 10 to 7, and then he leaves about 10 o'clock to help me with our daughter.
Does he live with you?
No, ma'am.
I'm sorry, he leaves at 10 o'clock a.m. or p.m.?
PM. around 10:30, 11-ish. It's always different due to our daughter because, you know, kids, they're different.
I don't have any other questions at this time, Your Honor.
All right, any questions from the defense?
No, Your Honor.
All right, thank you, ma'am.
Thank you.
You can stay right there while we finish the case if you want. That's okay. All right, so the probable cause affidavit is dated December 14th at midnight, 26 minutes after midnight. And it says that he said to law enforcement, he was there at 7 to watch the child, a.m.
They got here. I was sitting in the front at 12 o'clock. I was here.
Let me just look. Sometimes they write the date.
Yes, that's exactly what he did. That's right. Says a neighbor called and advised her staying.
All right, Counselor, here, the evidence that's before this court is that 26 minutes after midnight on December 14th, your client was found at the residence. There was no child. He shouldn't have been at the residence. I think that's sufficient for probable cause.
Excuse me, can I say something?
Your Honor, I don't.
Just a moment. Go ahead, Counselor.
It says at 23:38 is when he opened the front door and asked why he was there. And he was there to find the child, so it wasn't after midnight, but still.
Oh, it says at 026.
No, Your Honor, that's when they wrote the affidavit, but at approximately 23:38, I and assisting officers made contact.
All right, so 11:38 p.m.
But that's not indicating that that's his residence.
No, but it's indicating that he's in a place that he shouldn't be. He said he got there at 0700.
And Your Honor, I just disagree that that's a place he shouldn't be.
Can I?
Right, but it's not about opinions here. It's about the facts and the evidence. The evidence says he wasn't supposed to be there, and he was. And she just testified that she works from 7 a.m. to 10 p.m. around about.
And he stays there after I get off to help me with the baby.
Well, ma'am, you weren't there this night, and you called law enforcement and asked them to go to your house and check on whether he was there.
No, ma'am, that I did not call law enforcement.
All right, well, that's what's in the affidavit. It says that Brianna Howell called law enforcement because a neighbor advised him that the defendant was staying at her residence. Howell advised that Miller was violating a no-contact order, that you share a child in common, and that you asked law enforcement to go to your residence to ensure that he was not there.
I did not call law enforcement.
Are you Brianna Howell?
Yes, ma'am.
That's what's in the affidavit.
And Your Honor, we have testimony today from the same alleged caller who's saying that didn't happen and that this person is allowed to be there. I'm arguing that the order doesn't indicate that he can't be there, that there is no violation of the order. Just looking at all of what this is said in the police report, there is, even if all of this is true, There's no indication that he isn't allowed to be there. It just says he must maintain separate residence and no hostile contact. There's no indication that this is his residence just because he's there. That's when he's usually supposed to be there. So it seems like it's very confusing for my client when he's
I do agree with
usually
that.
there around that time. He's usually helping with the child. He's allowed to have contact with her. He just must have separate residence. There's no indication of hostile contact. There's no indication he doesn't have a separate residence, just that he's there without her, which the order says he has no indication that he shouldn't do that.
I thought it said something about him being there to watch the child.
That has to do with contact with the victim, which the only contact they had that day was about the child. There's nothing about the fact he can't be there but for the child.
It says to comply with seats.
I need to see this order.
Your Honor, I have a copy of it. I did write that, very confusing, but would you like me to bring it up?
Yes, please, please. I need to read it. I
Just-
agree, it's confusing.
Well, and just for clarification, the DCF case that is open, it's not with this child, it's with our little son. So he's allowed to see her whenever and he helps me out with her at night with her. Because I work until 10 o'clock.
It says that
So it says, the defendant may have contact with the victim solely to comply with the DCF plan. Defendant must maintain a separate residence. All other conditions remain in effect. I don't know what those other conditions are. Counsel, I think you're going to have to make this argument in front of the trial judge, because I think defendant must maintain a separate residence. And then, sir, please let me finish talking. Just, only one of us can talk at a time.
Your Honor, I did just speak to Ms. Eugene. She does agree that there is probable cause issues.
I don't think I agree with her. I think there's probable cause. It says he must maintain a separate residence.
He doesn't stay with
Ma'am, I'm going to say the same thing to you that I just said to him. Please let me finish talking. If you can't control yourself, you can leave my courtroom. Do you understand? You did say something. I heard you, and I can see your mouth moving. Sir, you can leave my courtroom if you can't control your outburst. Do you understand that? Let me finish what I'm saying. Thank you. Please don't talk till I'm finished with what I'm saying. The order says defendant must maintain a separate residence. In the affidavit, law enforcement finds him at her residence at, you're correct, 11:38 p.m., and they write the affidavit at 12:26 a.m. He tells law enforcement he's there to watch a child, but there are no children in the residence. So I think that's sufficient for probable cause that he violated this order. The order is on an aggravated battery upon a pregnant person, domestic battery by strangulation, neglect of a child, resisting with violence, and offense against a police dog. So it's a very violent case, and I think there's probable cause that he violated that part of the order, counselor. So I think you're gonna have to take this up with the trial judge. Now, what I'm going to do is, having found probable cause, I'm going to ask both of you in turn if you wish to be heard. Before you speak, Mr. Miller, I'm going to give you an opportunity to speak to your attorney because everything you say is being recorded and can be used against you later. So I don't want you to say anything unless you talk to your attorney first. Do you understand? I'm going to give you a moment to do that. Ma'am, I'm going to get to you in one moment. All right, Ms. Howell, is there something else you want to tell me?
I just wanted to touch on the fact that you said, that we're supposed to remain separate residents, correct?
Yes, that's the order.
He does not stay with me at all.
Good, he's not supposed to.
Okay, that's what I'm saying, like, and the only reason I wasn't there was because my auntie had literally just came and got me. And we went to my auntie's house, like, literally just came and got me and the baby. And,
So there was no reason for him to be there then?
no.
If his
he
sole
was- he
purpose
was
for
on
being there
his
was
way
to be
out.
with the baby,
No,
he
I'm
shouldn't have
saying
been there.
He was on his way out. We both were leaving at the same time. She had just got there before his ride had got there.
Okay, thank you.
And he has a job he needs to get to. He helps me pay my rent for our child, for both of our children. And even in the DCF case, they state that he's doing better. He's doing great with his children. He's doing great in everything.
All right, thank you, ma'am. Mr. Miller, is there something you want to say to me?
Your Honor, I'm going to speak on behalf of Mr. Miller first. I'm arguing that you take no action on whatever the same case that he's out on bond for. This is not violent at all. There's so much that goes in my client's favor as to this case, although we object to finding a probable cause. If you are to set a bond, we ask that you set a $100 bond. This is a misdemeanor. My client was there to help watch his child. To me, there's no indication he was doing anything other than that besides being there at 11:38. There's nothing violent in this police report. He is allowed to have a non-hostile client with the alleged victim. He does work. He works today. He needs to go to work in order to help provide for his children. Any money that he has to go towards bond goes against things for the children, as he's paying for a hotel every night. He's paying for the apartment of which his family is living. He's paying for all the food, all the diapers, everything. So we're asking that get taken into account when you're making release conditions, when you are setting a bond. We're arguing that there's no indication that there's anything violent happening and that there is anything that the court should be worried about. And he really just wants to comply with the DCF plan. He really wants to get his children back and eventually be reunified with his entire family so he can live there. But he has been trying to comply, and because the court order was confusing, we ask that you give him the benefit of the doubt and set a bond and not revoke any bond that he's out on.
Is there a hold for Manatee County?
No, Your Honor. It's just his out on bond that's holding him right now.
Oh, he's out on, no, in the Manatee County case, is he on probation?
No, he served time in DOC, but he's not on probation.
Okay, so he was released in March of 2021.
He was released in July.
Oh, July of 2021.
Your Honor, one more thing. My client starts domestic violence classes next week. He signed up for them. So we're asking that he be able to do that. if he's in jail, he's not able to comply with that. And it does take a good amount of time to get signed up for those classes. I believe they're once a week for like 9, 10 weeks.
26 weeks.
25 weeks. It's a
25 weeks, okay.
And he also has therapy classes he has set up too.
I'm sorry, what?
He also has therapy classes set up too.
How often is that?
Ma'am?
How often do you go to therapy?
I haven't started with CPP yet. The CPP case manager has to make a set schedule. They're
Okay.
still in the process because I have to start the DV classes
First.
and I have to start parenting. So they didn't want the case didn't put a bunch of stuff at one time.
Got it.
Did the defense file a written motion in this case, not this case, in the CF case? The order says defense motion for modification of no contact order granted. Was that a written motion?
I'll have to look that up, Your Honor.
And ma'am, you can either sit down outside if you want, or you can stay right there. It's up to you.
Okay.
There is a motion on 10/12.
Case manager that's assigned to our case, he does a home check, a random home check. I've passed all of them, and they have records of it in the CPS file.
All right, I found the defense motion. Does anyone have the DCF plan?
I'm looking right now.
I don't see that in this case.
I never know how to read these.
I'm sorry, what?
I never know how to read DCF cases. I'm looking through it. It does say that they're to maintain separate residence because of the criminal case.
Where does it say that he can be at that residence for the purpose of the kids?
At their visitation.
It would have to be in the DCF plan, because it's not in anything in the court file that I can find.
Excuse me,
Yes, ma'am?
for this baby, we don't have a DCF case open for her.
Any DCF case. The court order says that the defendant's motion for modification of no contact order and PTR conditions is granted, may have contact with the victim solely to comply with the DCF plan.
And I asked the case manager in the situation, I asked her, does that apply to her? Is he still allowed to see her? And she said yes, because DCF is not affiliated with her.
I just need that DCF plan. I'm not asking to which child it applies. I need to see that DCF plan.
Okay.
Do you have it?
I
With
have
you?
an email. I would have to go way downstairs to grab my phone.
I need to see that DCF plan, counselor, because your entire argument rests on that DCF plan saying he can be at that residence for purposes of the kids.
Would you guys like me to go downstairs and grab my phone?
Here it is, here it is.
I think she's looking for it right now.
Oh, okay.
Keeps shutting down.
So we might have to recall him as well, because I need to see that DCF plan in order to set bond conditions in this case and determine whether I'm revoking his bond. All right, here's what we're gonna do. We're gonna reset him for the end of the docket as well. Ms. Howell, can you hear me? Okay, what I'm gonna do is I'm gonna reset him for the end of the docket so I can give his attorney time to find that DCF plan. If you are able to access it and you want to do that, you can. I'm not ordering you to do anything. I'm just telling you that you can. And then you are welcome to come back to court. All right?
Your Honor, I'm having trouble with it. I think it's because I'm not really allowed to have access to dependency proceedings as I'm not his attorney. It keeps shutting down.
Then this will give you the opportunity to contact his attorney, because your entire argument rests on that being in that DCF plan.
But Your Honor, I believe that you might be able to get access to it, the case plan, because you should have unlimited.
I may be able to, but not right now, because I need to see all the other defendants.
Right.
So we can do that at the recess.
Okay.
But I'm gonna see the rest of the defendants and we'll come back to his case.
I'm looking.
Counsel, do you have the case number?
Oh, yes.
All right, let's do the next defendant. If you guys can do it while we're moving, that's fine.
Your Honor, I assume I'll be appointed on most of them.
Yes, I believe the order is still in place.
21 BP 351.
Okay, thanks.
Thank you.
So you're here in 21 MM 8817, charged with battery domestic violence. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Counselor, I see your client has one prior failure to appear, histories of domestics, violation of injunction. Wait, is this the victim is also here? We need to bring the victim in.
Your Honor, we're requesting them be seen separately.
Did you speak with each of them about that?
I didn't speak to either of them about that. I just think that it would be better for them to be separate. Just seeing how it was. I mean, they're both the victims, but don't, it could be. Your Honor, would you like me to confirm with the other alleged victim in the case? He's okay with being seen separately.
Yes, because they have a constitutional right to be heard and
So
to
should the
hear
state-
their victims
should-
testify.
Should the state attorney be speaking to the victims to determine that?
That's up to you guys. It doesn't matter to me, but you're the one asking to separate them, but they each have a constitutional right at stake here. So I'm not willing to ignore that right without them both saying that's what they want.
Your Honor, it just seems kind of adverse for me to be speaking to victims about their victims' rights. I mean, I believe that might be in the state's discretion, but I have no problem speaking to them as possible defense attorney, even though I haven't been appointed.
You will, I'll appoint you in both of these cases, understanding, of course, you'll have to conflict off of one of them. But the issue is You're correct. You would have to ask them, as the person charged with the crime, if they're willing to not hear their victim testify in court.
It seems strange that I'm advising them of their victim rights, though, because.
Not victim, defendant.
I understand, but I'm talking to them about the fact they're waiving their right as a victim.
No, you're not. What I'm saying is, the defendant also has the right to hear the victim testify. So it's you're the one asking me to tell your clients that they're not going to hear the victim in their case testify should the victim want to. So you should talk to your clients about that. You're correct, the state should talk to their victims, but I don't know if they did.
Your Honor,
Yes.
also for a past defendant, Angel Lorette, a victim did show up.
All right, we'll have to call that one later. Is this a DCF case? That's the dependency case? Yeah, that's not what that says at all. Is the state gonna talk to the victims?
I can, Your Honor.
It's up to you. I'm not telling you what to do. It's your case. But you heard what the PD is requesting.
Your Honor, I spoke to Ms. Pryor. She's okay with not hearing the victim's testimony.
And Mr. Mills is the same?
Okay with not hearing the victim's testimony as well.
All right. In this case, sir, your bond is $1,000. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. You must comply with any plan set in place by DCF. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
Your Honor, I do have something to say as to his bond. The failure to appear is from 2004, so that was almost 20 years ago. I'm asking that he be placed on pretrial release with a $100 bond as he does qualify. It's been a long time since he's been in trouble with the law.
I have that he does not qualify.
Yeah, that was updated. He doesn't qualify.
When was it updated?
Earlier, before I printed your copy and the PD's copy.
I use this.
Oh, yeah, your face sheet?
I don't use that really for that. It doesn't say it.
The face sheet does say it, but mine says he does not qualify. I do see that the failure to appear was in 2004. However, he has prior domestic violence history with the same victim, and he has previously violated injunctions for protection, which shows a lack of willingness or ability to comply with court orders. He has an out-of-state history. What says the state?
I apologize. What I have says that he does qualify for PTR, so he does or he does not.
He does not. Doesn't your face sheet say?
Wait, he does not?
He does not? He does not qualify.
I thought you said he does. Yeah, he does
Okay.
not.
So you got the more recent one. I'm sorry. Because it does say on here, verified community ties, and then on my, it's fine. If he doesn't qualify, then we're just asking for a reduced bond, $500.
I'm not inclined to do that. Good luck, sir.
Okay, you ready?
George Mooring.
Good morning, sir. You're here in 21 MM 8819, charged with battery, domestic violence. I'm going to appoint an attorney to represent you in this case. Counsel, did you wish to be heard?
No, I assume I do. Hold on. Let me go to the next page.
As to probable cause.
I don't have anything written, but doesn't mean that there isn't.
I reviewed the affidavit. I do think there's probable cause here. But before I made the finding, I was giving you the opportunity.
I don't believe I found any indication that I had trouble with this. Do you have it with you?
There's not.
Okay. Then no, I do have bond arguments.
All right, there is probable cause, sir. Go ahead, counsel.
Your Honor, my client has zero history. He is 49 years old. He's employed full-time for 2 years. He has a low-risk assessment. I'm asking for a non-monetary release, because there'd be no indication that he wouldn't show up for court. There's no indication that anything would ever happen in the future based on his prior history.
So I have that he has 2 arrests out of state or convictions out of state.
Yes.
His last one was in 1994. Go ahead.
Oh, I was about to say, he does have out-of-state history.
He has an out-of-state history. An out-of-state arrest for battery, resisting, aggravated assault, but I don't know if any of those were convictions. What says the state as to pretrial release?
I have no objection to pretrial release.
I'll place your client on pretrial release, but I'll still require that he post a monetary bond pursuant to the statute since this is a domestic violence case. However, I'll reduce that amount to $100. Sir, your conditions are you cannot return to the Orlando World Center Marriott for any reason. You can't have contact with the victim or any witness in this case. You can't possess any weapons, firearms, or ammunition. You can't possess or consume any alcoholic beverages. Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
There you go.
21 MM 8818, you're here charged with battery, domestic violence. At this time, I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500 with special conditions. You can have no contact with the victim. You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. And if DCF gets involved, you must comply with any plans set in place by DCF. Do you understand? All right, good luck, ma'am.
Johnny Torres.
21 MM 8826. Good morning, sir. You're here charged with battery, domestic violence. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500. You can have no contact with the victim. You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Are there any other conditions the state would request?
No, Your Honor.
You can have no contact with any witness in the case as well. All right, good luck, sir.
All right, Louis Villegas.
Good morning, sir. You're here in 21 MM 8825, charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Are there any other conditions the state would request?
No, Your Honor.
You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. Good luck.
Good morning, Devin Bevel.
Good morning, sir. You're here in 19 MM 1041 and 1042. Looks like you have 2 warrants out of Leon County. One is for fraudulent use of a credit card. Actually, they're both for fraudulent use of a credit card, just 2 different cases. Your bond on each is $1,000. We'll notify Leon County that you're here, but in the meantime, I'm going to appoint an attorney to represent you. They'll come and transport you to Leon County, but because you have bond, if you're able to post it, you can bond out here too.
Yes, ma'am. I paid the bond yesterday in the full amount.
For some reason?
There's
I don't see any.
no bonds have been processed. So I don't, no bonds have been processed, so I don't know what the holdup is.
Oh, so there's some kind of system problem because bonds aren't being processed? But you will be released if you posted the bond. I just don't know why it's taking so long.
So that means I'm good. I just have to wait to leave.
Just till they process the bond. But then why was he brought to court if he bonded yesterday?
They didn't process the bond, so I don't know if they're waiting on the other county. He probably paid the bondsman the money.
Oh, okay.
But
All right.
jail didn't get the.
Then you will be released from here once the bond is posted.
Okay, thank you.
Yes, sir. Good luck.
Anthony Pandolfo.
Good morning, sir. You're here in 21 CF 11957. A warrant was issued for your arrest out of Pinellas County for criminal mischief. The bond authorized is $5,000. If you want to post that bond, or if you're able to, you can. We'll also notify them that you're here, and in the meantime, I'll appoint an attorney to represent you here. Good luck, sir.
Douglas Stoneburner.
Good morning, sir. You're here for violating your probation in 21 CF 6319. A warrant was issued for your arrest. For that violation, there's no bond authorized. I'll appoint an attorney to represent you. The allegation is that you failed to report as directed, failed to complete or remain in drug or alcohol treatment as directed, and changed your residence without procuring the consent of your probation officer. Good luck, sir. I understand. You want to talk to your attorney about it because they need to make that argument in front of the trial judge. All right, so we don't have any more defendants, just the two that we continued. Let's bring back Ms. Bell. Ms. Bell?
Yes.
Okay, you're here in 21 MM 8823. This is the battery domestic violence case. Let me ask, does either side have any new or further argument to make?
Nothing from the state.
No, Your Honor, I just renew my previous objection.
May I say something or no?
Ma'am, you can say anything you wish, but everything you say is being recorded and can be used against you later. Do you understand that?
Yes, ma'am.
Do you want to talk to me or do you want to talk to your attorney first?
I can talk to my attorney first.
All right, ma'am, did you want to say anything to me?
No, ma'am.
All right, counsel, did that change it? Do you want to say anything else on behalf of your client? All right. This is a really unusual case, and your argument is very convincing. For the charge of battery, the state has to prove two elements, that there was an intentional touching and that it was against someone's will. In this affidavit, which is the only evidence the court has before it, I believe there is evidence of an intentional touching because there's an independent witness, possibly two, who state that they witnessed the defendant and the victim physically fighting. So the physical fight is an intentional touching. However, the second element is that it be against the will of the victim. And in the affidavit, the victim tells law enforcement that he scratched himself out of anger during the argument. So at this time, I'm going to find there is no probable cause and release you on your own recognizance, Ms. Bell. Now, I want to make sure that you stay in touch with your attorney. This does not mean that the state of Florida won't still file criminal charges against you. So make sure that you stay in touch with your attorney because the state of Florida is the one charging you with a crime, not the court. You understand?
Yes, ma'am.
All right. Good luck.
Thank you. Thank you.
Ms. Howell, can you hear me? I was able to get the plan, so I'm going to review that. We're going to take a recess. I'm going to review that, and we'll take this case up first when we come back. How long does everyone want? 30 minutes?
20 minutes.
She says 20.
20's fine with me.
20?
I'll take 30.
All right, so we're going to take a 30-minute recess. I'm going to review this, and we'll come back and address the case. So, but I have the plan. I just didn't want you thinking that you needed to scramble to find it, okay? All right, I'll see you in a few minutes. A victim who came.
You want to do that now or in 30? Oh, okay.
Yeah, because the victim came, I don't want to make the victim wait. Sir, please tell me your name again.
Angel Lodrat.
All right, so this is 21 MM 8828. Ma'am, are you here to testify in that case? Do you wish to testify? Is that no?
Yeah, no.
Okay, so we've already addressed this case. Can you tell me what I ordered? I placed him on pretrial release. He can have no contact with the victim, random urinalysis, can't possess alcohol, cannot possess weapons, firearms, or ammunition, must maintain a separate residence, one-time return with law enforcement to gather his belongings. So those are the conditions of his release.
I was wondering if the no contract can't be there because we do have things that we financially need to discuss that intertwine both of us that require contact.
So not at this time. The only evidence that the court has is the affidavit, and without victim testimony, I'm not inclined to allow any kind of contact. Did you have any other questions?
No, not really, no.
All right, good luck, ma'am. Thank you, sir. Good luck.
Your Honor, may I see if she would like to be called as a witness?
Yes, stay right there for one moment.
Ma'am, would you like to testify as to your contact and, yes?
Sure.
I'm sorry, have you been sworn in?
No.
No.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Talia Flores, Flores.
All right, let me ask, does the state have any questions for Ms. Flores?
Good morning. How do you know the
Sir?
defendant?
Look at me or that wall.
I'm sorry?
How do you know the defendant?
We're boyfriend and girlfriend.
Has something like this happened before?
Not really, no.
Would you like to have contact with him?
Yes, I would. Because like I said, we do have things that are financially intertwined, and I don't feel for my safety from him or anything. I feel like it was just a thing of emotions that got the best of both of us.
Okay. I have no further questions, Your Honor.
All right, thank you. Anything from the defense?
Yes, Your Honor. Ms. Flores, do you guys have separate houses?
At the moment, no.
Would you want him to return to where you're living?
For the moment, yes, like I said, I do not fear for my safety from him, and I know he actually does not have nowhere else to go at the moment. I don't want him to be put on the streets or anything like that. But I don't fear for my safety from him. I feel like I said, our emotions got the best of us.
Would you call the police if you felt threatened in any way?
I would if I did, but I don't feel threatened by him. I do have one thing though. If I could get the no contract thing released, would it be possible for him to get anger management classes?
So unfortunately, ma'am, I can't, I'm not sentencing him today, so I can't order him to do anything like that. However, if the state files these charges, that can be something that the court orders if he pleads guilty or is found guilty by trial at jury. So I can't do that today, though.
Understood.
Your Honor, no further questions. I just ask for no hostile contact. We leave it in your discretion as you believe they should have live-in separate residence or not. We believe that, having some sort of contact, no hostile, would be beneficial for both parties, and that the alleged victim would not have any problem getting the police involved if something were to happen. But due to his lack of any criminal history and the victim's testimony, we ask for no hostile contact.
Thank you. What says the state?
Ms. Davis, is there a reason that he didn't qualify for PTR?
I believe we put him on with a $100 bond.
We did.
Oh, I'm so sorry.
I'm only asking for the change in the contact order.
Based on victim testimony.
I have no objection based on victim testimony.
All right, ma'am, here's what I'm going to do. I'm going to modify my order. Sir, I'm going to allow you to have peaceful contact only with the victim. That means no hostile contact. You can't push her, shove her, hit her, no yelling. Don't even raise your voice. Do you understand?
Yes, ma'am.
I'm also going to strike the maintain separate because I'm allowing contact. All right, good luck, sir. Good luck, ma'am. Thank you for coming.
Thank you.
And y'all, I forgot about the 33-day motions. Do you want to do those this morning?
Sure.
Let's do those and then we'll recess.
Let me know when you're ready.
I'm ready.
William Varner, 21 CF 14227, granted notice of non-filing.